So good afternoon, everyone. Excited to have you all join us for this call. My name is Jeff Rogan. I'm the Director of Member Services here at ARA. Excited to get this webinar series kicked off this year. I've been with the association for 2 years now. And so far, it's been an interesting time coming in during COVID and being able to deal with all of the issues and situations that have come along with that. I do want to introduce to you Shannon Dinwiddie. She is our Region 10 account specialist. Any concerns, any questions around membership, benefits, anything that we can help you with, she's going to be your direct point of contact. So I want to quickly introduce Shannon.
Hello. Yeah, please. I put my contact information in the chat there. So keep that handy. Do not hesitate to reach out to me. Anytime you have a question, I'm here to help maneuver you through everything that your membership has to offer. So I look forward to working with you all.
Fantastic. Thanks, Shannon. And then also want to introduce Michael Comartin from Ogletree Deakins. They are I'll let him explain exactly who they are, but he will be hosting or really leading the conversation today. So Michael, if you want to introduce yourself.
Sure. Good afternoon, everybody. And I'll apologize in advance if I cough a little bit. I wasn't feeling well last week, and I'm still sort of getting over things. And I also apologize that I think I put the presentation on. Hopefully, everybody can see it, but I kind of cut Jeff off there when he was talking. I took him away from the picture. So my name is Michael Comartin. I'm a partner in Ogletree Deakins in Toronto. We're going to go through a little bit of history of the Canadian branch of the firm a little bit later. There we go. So I just wanted to make sure that introduce myself very quickly, and then Jeff, in terms of the presentation, do you want to share your screen now? Go through your slides first, and then kick it over to me, and then I'll share my screen after that.
Yeah, let me pull it up. Do you have it handy? Because if I can have you click through it as well.
Yeah, that's fine as well. We'll see whether or not I can actually operate it on the fly. So if you want to do that, we'll see if I can if I'm able to do that. We'll see. Okay. All right. Let me just see. Is that now? Are you able to? Is everybody able to see this? See the presentation?
Yes.
Perfect. All right. So why don't we go ahead, Jeff? I'll put it. I'll go through the very quickly what the order will be for today. But then I think what we'll do is let you talk for the first little bit. I'm just going to see. There we go. So this obviously Jeff's more adept at accessing the ARA website than I am. So he'll cover the first part of this. Then I'm going to talk a little bit about the member benefits and about our firm. A little bit about current human resources issues of interest. Obviously, during the pandemic, there's been quite a few new things that we've all had to learn. And then hopefully we have some time at the end for a Q&A session. So over to you, Jeff.
All right, fantastic. So what I wanted to do is just spend a couple minutes so that you guys knew how to log into that portal for Ogletree with any questions. So the first slide, basically, once you get logged in, I have the circle by the resources tab. From there, you'll click down into the human resource assistance button. Once you click on that, it's going to take you to a secondary login, and it will only do this for the first time. Mike, if you want to go to the next slide, one time you will have to do this. It will be your same username and password that you use to sign into the website. You can click the remember my login, and then you won't have to do this page again. Once you're into the microsite, there's a couple things I wanted to point out. There's the tab that says device requested form. That is where you can go to take advantage of the 2 free hours of legal human resource consultation. You get 2 free calls up to 2 hours in total that they'll be able to help answer any specific questions you may have. You know, and what's great about Ogletree is I believe we have 2 offices. One's in Toronto and one's in Quebec, if I'm not mistaken. And Michael will get a little bit more into that. But this is where you would go to fill out that form. And to access Canada-specific materials, you can simply type in the search box Canada, and it will pull up all the current information that we have available through Ogletree that's on there. things that are of relevance to you. You can also click on the Ogletree Deakins box in the upper right-hand corner, and what that's going to do is take you directly to Ogletree's website. When you first pull it up, I don't know if it will remember or not, but you're able to go to where I have it circled, change the flag to the flag of Canada, and then you have the option of having it either in English or in French. And then what that's going to do is really give you additional Canadian specific benefits as you kind of work through the site.
Great, thank you, Jeff. So as Jeff mentioned, this partnership with the ARA has certain benefits, particularly in terms of access to sort of what I'll call like off the cuff advice, where you have a question or two, but doesn't really necessitate setting up an individual retainer with a law firm. It gives you an opportunity to fill in that advice request form and speak to myself or another one of my colleagues. So a little bit about our firm. So Ogletree Deakins PC is a very large U.S. labor and employment law firm, but over the years has expanded into Mexico, the EU, the UK, and into Canada. We have 2 offices in Canada. The first office was opened in January of 2016 here in Toronto. I was part of the opening group of lawyers for that office. And then in 2019, we expanded into Montreal. So we have people licensed in Quebec who are fully bilingual and can provide services in both official languages. And in addition to having physical offices in these locations, we also do provide general advice services in relation to other provinces. Subject obviously to some things require local counsel, but typically most things that you'd have a one-off question about, we've dealt with them for a local client in another province. As Jeff mentioned, that the membership benefit is really just about 1 or 2 points of contact, a call and an email or something like that, twice a year to a maximum of 2 hours of time. Again, the goal of that is really to help with these sort of nitpicky one-off questions that you might have about some practical advice in a situation. It's obviously not intended for things like representing a member in a dispute or litigation or something like that. However, if you end up in a situation where you do need access to a different set of legal services or something that's a bit more involved, there's a preferred pricing set up with ARA members, and you can contact myself or our firm about that if that's something that you might be interested in. So part of what we've done with the membership webpage is provide access to a number of articles and a number of other resources on Canadian employment and labor laws and sort of updates and things like that. We've included province-specific employment desk references, which are short summaries of local labor and employment law concepts. As of right now, we only have Ontario and Quebec listed there, but I expect in the next couple of months, we'll probably be adding a couple other provinces. I expect the next 2 would probably be BC and Alberta, just based on the volume of work in those provinces. But the idea is basically that this is something where if you just need a little bit of assistance with a question, you want to know what the overtime rules are in Alberta, for instance, or the overtime rules in Ontario or Quebec, or whatever it is, you can just go in and take a look at that and get some very quick advice. I think over time, the plan is to keep adding more resources to this, perhaps summary charts of typical employment standards issues, things that can be easily summarized in a written form and don't necessarily need, you have to call a lawyer to ask the questions. Okay. So we're going to go on to the next section today, which is just talking a little bit about current issues of interest. COVID reopening. I promise we will not talk about COVID restrictions very much. I'm sure we're all COVIDed out at this point, but there are some interesting issues that are emerging now because of the reopening and some of the HR issues that are surround that. The second will be hiring retention issues, some interesting client discussions on those and might be of value to members. And then the third will be a bit of a legislative update. There's been some interesting legislative changes, particularly in BC and Ontario, that I'm sure you've heard quite a bit about. So, as I say, I promise this is the only part that's going to deal with COVID today. Most provinces are ending their restrictions now. Fingers crossed that these will be permanent and we won't be locked down again in the fall or the winter, but you never A lot of these things that are being removed, though, are the more onerous restrictions, but some of the very basic ones like mask requirements and screening for workers when they come into a physical workplace, they're likely to continue at least for the foreseeable future in some provinces. Certainly Ontario and Quebec have indicated that's the case. Other provinces are moving away from things like masking, but for the most part, that's still part of the matrix we have to deal with. The ending of again, and this is well known publicly, the ending of mandatory work from home and vaccine passports in virtually all provinces is either happened now or is close. But what's interesting is that some provinces, including Ontario, have specified that businesses can still themselves choose to require vaccine passport or proof of vaccination to enter a workplace. Of course, that raises some issues for employers and for ARA members, because your workforce may be going into another employer's work site, and that can obviously have some issues if there's still vaccine passport requirements in that workplace. One of the things we did, rather than again trying to summarize everything for you today, was upload a list into the membership portal, and hopefully I did it properly, of sort of the current reopening information sources that might be useful to people. So for instance, in Ontario, it's a link to the Ministry of, I can't remember if it's labor or if it's just a general government website talking about COVID restrictions. In some cases, it's a news source or whatever it is that is a very good source of keeping you up to date on that. So that's a quick sort of scroll, click a link, and you can get to the most up-to-date information without having to go through articles and things that summarize it. You can go straight to the source. Of course, if you have questions about that, that's exactly the kind of question that is perfect for the advice form, if you have a specific question. So with the sort of the ending of vaccine passport programs and mandatory vaccination or proof of vaccination programs, there's a couple of questions that have come up either with clients or that I'm anticipating will come up with clients, which are probably likely to come up for at least some of the members of that are on this presentation. So, for example, now this was obviously more the case in industries where there was a mandatory government issue, and a little bit less common where it was an optional requirement. But what do we do with respect to employees that were terminated or suspended for non-compliance with a mandatory vaccination program? So, 6 months ago or a year ago, the government said you had to have people vaccinated, or the client where the person was going to work said you have to have all your people come in and be vaccinated before they can come to our work site. Well, what do we do now when those folks have either been terminated or suspended? Are they brought back to work? Does this weaken a termination case if we were saying, for instance, that it's cause to terminate? That's a really good question. And frankly, that's one where the governments have kind of left employers to deal with the issue without actually addressing the fact that employers were the guardians of public health in that respect, and were carrying out the government's mandate, and now the mandate is gone. And somebody terminated 6 months or a year ago under a mandate is by the time they get to a court, it's likely that the judge that isn't going to be looking at active legislation requiring this, and it could color that analysis a bit. New hire policies. So this was something that a lot of employers did, and something that we had advised most of our clients that they could do, which was to require vaccination for people who are joining the employer for the first time, right? Subject to obviously accommodation of medical or religious issues. Now, the question becomes, if that policy was put in place as an employer, how long do you want to keep that policy for? And is it going to be for access to your specific work site, or is it going to be about access to client specific sites or client work sites or a construction site or whatever it is? How do you mesh those things? And then sort of a related issue is what happens with clients that have implemented these mandatory vaccination policies? And there are quite a few in virtually every industry. What we haven't seen yet is whether or not those clients and large employers, large construction employers, or large other retail. There's so many different industries that have these requirements. Are they going to rescind those policies? And if not, is that going to change how you manage your workforce? Because one of the most common issues that I dealt with, and I imagine that many of you dealt with during the pandemic, was what do we do if a customer won't allow our employee on site because they're either not vaccinated or not willing to prove vaccination? That can be an interesting question, because now that the public health orders are going away, it'll be, it remains to be seen whether or not the large customers, clients, large contractors, and things that implemented a lot of these policies will start rescinding them, and also whether they'll rescind them for the employees of other companies or just for their own. So that's it for COVID discussion today. I promise there won't be any more on that. But this is an issue that, again, has emerged coming out of the pandemic, is what to do in terms of hiring and retention. So I obviously don't need to tell anybody here about the issues that have come up with respect to labor shortages and how difficult it is to hire people and to retain people. The removal of mandatory vaccination might assist with this to some extent. I do know that in the healthcare sector, for instance, that's one of the reasons the government's kind of backed off on that requirement, was that they didn't have enough staff, and they were desperate, and so they wanted to make sure they could hire anybody that had the qualifications. Two anecdotes I wanted to talk a little bit about here, because they may be of interest. One of my clients spoke to me about the issues they were having, not only with the delays in background check, but also in terms of they were trying to accelerate their hiring practices. And one of the solutions that they had come up with, which I cautioned them on, was the idea of waiving the background checks that they would normally run, having a person sign a document indicating that what they have told them about criminal record and other things is true, they don't have a criminal record, etc., and then do the background check process while the person's already employed. Now, obviously, that can create a lot of issues with respect to, if you bring somebody onto the work site, they tell you that they're honest and that they don't have a criminal record for theft or something else that might be relevant to the job. And then, in the time between when they make that representation and when you can complete the background check, it turns out that that's not true. Now, if that happens, obviously, you're in a better position because you took the step of making sure that the person had signed something that said, I swear this is true, and if it's not, it's cause to terminate. But it doesn't change the issues that you face in terms of the risks that employer faces while the person is in the workplace before the background checks can be run. So I mentioned this because it's something that other clients have mentioned to me over the years in different contexts, and I suspect it's something that between the labor shortages and the delays in getting background checks run might become more common and might be something that employers will consider. The second client anecdote I wanted to chat about a bit is with respect to the rise of remote work, and I think during the early days of the pandemic, most of us thought that remote work would only affect businesses where remote work was easily implemented and would be viable for most of the workforce. So if somebody works in tech or in banking or in professional services, something like that, it's very easy to implement work from home and remote work. It's not obviously as easy in the industries that the ARA members are going to be working in. But the problem has become the competition from employers that do offer remote work affecting the employers that can't offer remote work is definitely something that some of my clients have told me about, at least again anecdotally. And second to that is the expansion of the labor pool outside of the larger cities into places where maybe those large employers would not otherwise be. So the best example I have is a client that's a technology firm, and normally they would probably be trying to recruit, dozens of people a year in Vancouver, Toronto, Calgary, Montreal, maybe Ottawa, like in the larger urban centers. And the last I spoke to them, they were actually opening up a very large office, with remote options as well, but also having a physical presence in Atlantic Canada, in a market they would normally not have gone, except that the rise of remote work, the pandemic, et cetera, meant that a larger share of the workforce with that talent set and that talent skill set was now living in Atlantic Canada, and they were able to offer compensation to those folks that would be very competitive in the local market, And obviously, it's not everybody that works in that office is going to be drawn from the people that didn't live in Atlantic Canada until the pandemic. So there's, again, that's an example where the local market may be influenced by the fact that people from Toronto, Vancouver, Calgary, and other surrounding large metropolitan areas have expanded out into other places. And then on the contrary side, that creates a bit of a labor shortage in those large urban centers. So whether you're in the urban centers or not, you can be affected by this. And it's something that I have seen from multiple clients of different sizes chatting about that issue when we're dealing with this, because they're having issues with retaining people. Often they're coming to me because they want me to, threaten a non-compete or something like that. They're not asking me to help them staff their workplace, but they're asking me about, okay, can I enforce this non-solicit or non-compete? And then these discussions come up. So I mentioned this largely because it is something that interacts with the legal advice that you may get from a lawyer day to day, or the practical advice you may want to implement in your human resources practices, which is to understand not only the relationship between why you have, say, legal issues, or you have a previous employer threatening over a non-compete or a non-solicit, coupled with the labor market issues that Canada is experiencing right now. Retention, not just in terms of not just in terms of the sort of the market competition, but also in terms of engagement. So this is another issue where I've had, I would say, in the last year or two, probably more cases of this nature than I've had my entire career, more than a decade before that. Is, an employee still works for us, but they're not doing anything. They've basically shut off. They're not answering. They're not, again, with remote work, it's a little easier for people to do this than it is when they work in person. But it affects, salespeople. It affects all managers. It affects all sorts of different folks. And what's been happening, again, anecdotally, is a lot of people are not quitting. They're either trying to get fired, or they are sort of slacking off, either because of burnout or other issues. And it's leading my clients to have to take on potential legal risk to deal with employees that aren't performing. And anyone who has done human resources or employment law for any length of time will tell you it's extremely hard to fire somebody for poor performance. So obviously these folks are exploiting that fact, and it has become a source of quite a lot of issues for some of my clients. Again, not that people are doing anything wrong in the sense of they're not stealing, they're not harassing or engaging in workplace violence or anything like that, but they're just so disengaged that they're not performing their jobs, and it's difficult to get rid of those folks without terminating them and giving them a severance package. So again, that's another issue that has come up quite a bit in the last year or so. Another topic, again, which I hope people haven't seen, but I'm willing to bet if you're in BC you have, is the abuse of the various forms of sick leave that have been implemented in the last year. So I believe all or almost all provinces have a form of paid sick leave that at least deals with isolation or quarantine due to symptoms of COVID-19. But BC has actually implemented a more expansive sick pay law, paid sick pay law, that I'll talk about in a little bit. And I have heard some of the most egregious forms of complaints of abuse of the sick leave laws. The most sort of extreme example I had was a client that called me and said, so-and-so has told me they're resigning in 2 weeks. They want to use 5 paid sick days for half of the time. And of course I said, that's not what that's for. But the brazenness with which people will ask for these things, I think reflects what I'll talk about in a minute, which is sort of the expansion of, or the entrenching of rights of employees and rights of labor in a way that we probably haven't seen, at least in since the financial crisis in 2008. I mean, it's certainly in my career, I haven't seen anything like it, where somebody would be as brazen as saying, I would just like to take my 5 paid sick leave days, please. And of course, this was 2 or 3 weeks after the 5 paid sick leaves became law. So speaking of which, the legislative update part. So in BC, there is now a 5-day paid sick leave law. It applies to all employees. This was effective the 1st of January. It's a calendar-based system, so every year the 5 days resets. You can't carry them over, but you get 5 days on January 1, and you could theoretically have an employee that plans to quit who on December 31st decides, well, on January 2nd, I'm going to take sick days for 5 days, and then I'm going to quit after that. The calculation is fairly simple. It's just averaging the last 30 days wages for the value of a day. But this does apply to all employees. It applies to part-time, it applies to temporary, it doesn't matter. And it's not prorated in any fashion either. It's currently permissible to use it for isolation and quarantine for COVID-19 as well as for regular sickness, which obviously makes some sense because the government was never going to eliminate using it for quarantine or isolation. The question, again, the second most common question after how do I deal with abuse of this that I've received so far is, what can I ask for? Can I ask for doctor's notes? Can I ask for evidence? The answer is yes, but the Ministry of Labor has clarified that it has to be a reasonable request for evidence. Otherwise, you can't insist on it. So the example I give is if an employee that you know has a history of migraines calls in and says, I can't come in today, I have a migraine, asking them to go to the doctor to get a note to prove they have a migraine is not a reasonable request. On the other hand, if an employee with a history of abuse of sick leave or history of absenteeism gives a vague reason for why they need 5 days off sick with pay, that would be a situation in which a doctor's note or some other evidence would be reasonable. And so we're in kind of a very similar situation that we would be with the COVID-related sick leaves, which is you can't theoretically ask for a doctor's note just for, I have the sniffles, I have a headache, I have a fever, whatever it is. But if somebody's request is unreasonable or somebody's request is suspicious, my advice to clients has typically been ask for the evidence and provide the pay later if they can provide the evidence, as opposed to just letting it go ahead if you have a reasonable basis to suspect that there's abuse. One thing, again, not to make predictions that could turn out to be incorrect, but I do suspect we may see more provinces creating permanent sick pay or sick leave days with pay, simply because, again, one of the things that's come out of the pandemic is the idea of the protection of the rights of workers who are sick and other things, and the expectation that employers be fair and reasonable with respect to providing paid sick leave. This is, it's a bit of a political issue, obviously, in some provinces. It's becoming, I think, a political issue in Ontario, which we'll talk about in a second, because there's an election in this province later this year. But this may be one of the trends that we see in HR and in employment law in the next couple of years, is the expansion of employee rights and the expansion of employee protections, particularly in areas like sick leave or things like that. So Ontario, very major legislation just came in dealing with a number of items, but really two main ones for employers in Ontario. The first is the rules that prohibit post-employment non-compete agreements. So there's a couple of words there in a long string of words. Post-employment non-compete agreements. So the legislation that was recently passed in Ontario does not address non-solicitation agreements. It doesn't address confidentiality. It also doesn't prohibit you from having rules restricting your employees from moonlighting or from competing with you while they're still employed with you. All that it does is it says you cannot create a non-compete agreement after the date it came into force in October with respect to what the person does after employment, unless it's part of a sale of a business transaction, or the person is a chief executive. Chief executive isn't defined completely. It is defined as certain job categories, and within that there's room for other forms of executives. So I typically say if the person is in charge of an entire function within a business, so if their title is chief something, CEO, CFO, those things obviously, but also chief human resources officer, chief privacy officer, things like that. It is a little bit broader than just what you would think of as a traditional C-suite. but there's some room for interpretation there. We don't have any case law on that yet. We do have some case law that has indicated this change is not retroactive. So if you have a valid non-compete that was signed in 2020 or before that, or before October of 2021, that non-compete would continue to be in force. It just cannot be created again after that date in October of 2021. My last comment about the non-compete agreement section or Bill 27 is I had lunch with a friend of mine that is in the Ministry of Labor about this issue back in the fall, and her comment to me was, we don't understand, and nobody really knows, and nobody really understands why this was done. It wasn't really anything that anybody was asking for as far as we could tell, but it was just something that became the law. And I think this is probably the strictest form of prohibition of a non-compete anywhere in North America, at least. I can't speak to Europe, but certainly stronger even than in Quebec, and Quebec had always had very strong laws over this. Now, the second issue under Bill 27, which I think is probably the bigger issue for a lot of employers, is the right to disconnect policy requirement, because this is a completely new idea in Ontario. There's and frankly in Canada, there's really never been a concept of a right to disconnect policy before this legislation came into force. Now, excuse me. The right to disconnect is defined as not engaging in work-related communications, emails, calls, video calls, or sending or reviewing messages in order to be free from the performance of work, which is, I mean, it's common sense definition. It's basically saying if it's after hours and you're working, then you haven't disconnected. So the policy is meant to reflect your right to disconnect from work, after hours. Now the problem with that is there's actually no new rules on what it means to disconnect. There's nothing that says that your policy can be that managers have no right to disconnect. There's really nothing in the regulations. And we'll go into this in a bit more detail in a moment. There's nothing in the regulations that tell you what's really supposed to be in here. I have some suggestions, and the Ministry of Labor's website has a few suggestions of how to do this, but it's a very vague requirement at this time. So a written posted policy is required for employers with 25 or more employees in Ontario. This is an annual requirement. And again, it only counts the employees in Ontario. It doesn't count your employees in all of Canada, which is a very good thing, obviously, for medium-sized employers, that they might be able to avoid this requirement. This policy has to be updated every year. It has to be posted every year. You have to check every year whether or not you have 25 or more employees as of January 1 to determine whether or not you have to comply. The policy has to obviously be circulated to employees. You as the employer get to determine what the policy says, at least until there are new regulations that might affect this. As long as the rules respecting hours of work, break times, rest times, vacation, and holiday pays, and obviously overtime too, holiday rules are all observed, you can more or less do whatever you want in the policy, whatever makes sense in your workplace. The policy, there doesn't have to be one policy for every employee, but there must be a policy for every employee. So for example, you could have a policy that has different sections. One deals with your hourly employees, where the section, the policy should be fairly strict, which is if you're an hourly employee, you don't perform work outside of work, right? You don't, you're not to be working after hours or incurring unauthorized overtime, things like that. And then your policy for your managers, your executives, your salespeople, et cetera, might be that you get the job done, and if you have to work after hours, you have to work after hours. And if they're not eligible for overtime, then it's just part of their job. And again, that could be in two different policies. It could be one policy. It doesn't even have to be in a standalone policy. It can just be in your handbooks. It could be in your other policies, your general HR guides or manuals. So there's a lot of ways to achieve compliance with this requirement, not all of which are the sort of draconian, we have a very strict independent policy posted everywhere that nobody ever has to answer an email after 5 o'clock on any weekday and never on the weekends. So I've had some clients that are a little bit freaked out thinking that that's where we've gone. And the good news is we haven't. So as I said, the Ministry of Labor and the regulations are basically bereft of any real requirements at this point, other than obviously respecting the existing rules under the Employment Standards Act with respect to breaks and hours of work and what constitutes performing work. But in terms of what your policy can and probably should address, the expectations for either all employees or a class of employees or a group of employees on what they're supposed to do or what they're expected to do on after hours work in terms of responsiveness. So again, for example, are you expecting your hourly workers to respond to work emails after hours when they're at home? If so, how do they record their time? How do you deal with it? Because it is probably considered in most cases to be engaging in work, and therefore, you have to track those hours if they're an hourly employee. Separating expectations to different employees. So for instance, if the managers and the employees and non-managerial employees are all included in one policy, that's fine, but you need to separate how they work and say, okay, for managers, and thinking here of overtime exempt managers, this is the rules for you. Your job is to get the job done. You need to do this. You need to be responsive. Maybe not on your vacation, but certainly after hours doesn't mean you shouldn't respond to emails. Hourly employees, clerical employees, here's the set of rules for you folks. And then out of office and voicemail, which I found a very strange thing for the Ministry of Labor to really want to have in a policy, but it was one of the things that they've indicated makes sense to include in there, which is, and again, thinking more of your hourly employees or folks who aren't expected to work outside of the regular business hours, indicating what you're expected to do if you're going on vacation and what your out of office voicemail should say or what your out of office email should say, so that you're not being interrupted on your vacation, because again, vacation is one of those things where you're not supposed to be performing work. So to sort of conclude on this, I see this policy requirement not as a new legal standard for what you have to do or not do as an employer, what employees can and can't do. It's really about forcing employers to codify into writing what their expectations are within the boundaries of the existing rules on overtime, hours of work, things like that. And it doesn't really create any new requirements. And so it in some ways it's a letter drafting process or a document drafting process. But in other ways, it's a good reminder to go back and think, okay, am I actually complying with the overtime rules? Am I complying with the rules with respect to hourly workers and whether or not answering an email outside of work is considered paid work time? So that's it for that issue, but that's certainly one that Ontario employers will be grappling with. The first policy was required on June 2nd of this year. So we have some time to get prepared for that, but it is something that will rapidly approach if you don't get out ahead of it. The last legislative update I wanted to include was Saskatchewan, just because they happened to pass some fairly comprehensive legislation near the start of this year, changed a few different rules. One, which was a very surprising change, particularly for Saskatchewan, was to expand the eligibility to unionize to include supervisors, whereas presumably supervisors typically aren't allowed to unionize. Now, there's a difference between working supervisors and non-working supervisors, obviously, but Saskatchewan was expanding potential labor rights, which is very unusual particularly for Saskatchewan. Employment standards legislation, they actually passed a part of their employment standards legislation that actually specifies that you have to provide alternative testing if you have a mandatory vaccination policy. Now, I think that has since largely been rendered moot by the fact that most of the mandatory vaccination policy requirements are going away this year anyway. But if you were one of those employers that chose to keep a mandatory vaccination policy, Saskatchewan is one of the few places that will mandate that you allow testing as an alternative, and even specifies the intervals of testing. Most provinces have left that up to the individual employers to figure out. And then lastly, Saskatchewan is expanding their workplace harassment protections to include students, volunteers, and independent contractors, which really moves them more to be in line with places like Ontario, Alberta, where the definition of who is covered by workplace harassment is not employees or full-time employees, it's workers. So it includes independent contractors, it includes volunteers and other things. So interesting update there, not necessarily as critical an update as what we've seen in BC or Ontario, but still some interesting moves there if you happen to have a workforce in Saskatchewan. Excuse me. So that's it for me. I've talked quite a bit today. There is time now for questions, but also just a reminder, the advice request form that we talked about at the top of the presentation is perfect if you have a question that is specific to your workforce and you need a little bit of quick advice. it's one way to just get that done rather than having to ask it in an open forum like this, which might not be appropriate. And lastly, I'll put this up here, my contact information, which is, again, useful if you need to contact me, but obviously the advice request form that you have through the member portal is the best way to initiate contact under that system. So I don't want to dissuade anybody from doing it that way, but there we go. And then I think I'm going to just cancel the sharing the screen here, Jeff, and we can come back in and maybe deal with some questions if there's a little bit of time. Yeah, we've got a little bit of time.
Sounds good.
All right, so let's see, because I got the chat here, and I apologize, I have not been monitoring the chat, obviously, because I've been busy. I've been busy chatting. I've been busy talking about the presentation, but let me just see if I can get this open now. Okay. Let me just see. Maybe I don't have any questions. Let me just see. Oh, here we go. Got a question about the 5 days in BC. Yes. So my understanding, the question is a good question. So basically, when dealing with the 5 paid sick days, it's 5 days as of Jan 1. However, if your employee starts April 1, they get 5 days. Well, as of Jan 1, and then another 5 from April of 2021 through April. So I'm gonna interpret this question to mean if somebody starts partway through the year, what happens? To my understanding, if somebody starts partway through the year, they still get the 5 days. It's not prorated. It's 5 days per year. Now, if they started and if they joined you and left and came back, I'd have to look that up because that would be unusual. But I still think they're only entitled to 5 days per year. And I do believe it resets January 1, even if they get hired, say, in June. It really is each calendar year they're entitled to 5 days. If you have a unique situation in which you've got, say, somebody who joined, left, came back, something like that, please reach out to me separately and we'll get you the answer to that, because I don't know that one off the top of my head. I haven't had that yet because it's only been in force for 2 months. But yes, it is 5 calendar days. It shouldn't be 10 in a year unless this is a very unusual situation. I will mention, sorry. Thank you.
Let me clarify that. So I phoned labor standards here in BC about this particular topic, just so we were clear of all the details. And how they explained it to me was previous employees. So say I've got someone that started April 1st, 2021.
Yeah.
They get 5 days up until April 1st. And then as of April 1st, their anniversary date of their hire, it resets. And then it will not be January to January. Moving forward, it will be April 1 through April 1. And so every staff member will be different. So this year, specifically, they get the first 5 days and then potentially another 5 days this year if they started near the beginning of the year.
And did they have sick days in April of 2021 under your company policy or something like that? Because how did they have 5 sick days before?
Because the government implemented it as they wanted as their anniversary date of when they began employment. So for now, this is the only year it'll affect.
Oh,
yeah.
Okay.
This is the only year it'll affect. So if someone started April 1st, they'll get 5 days technically between January 1 and April 1. And then moving forward, everybody will have their own anniversary date. It's rather frustrating, actually.
Yeah.
I'd rather
I'm
just
shocked.
January and
Yeah, especially because it's the retroactive effect of it, because the person wouldn't have had 5 days granted on April 1 of 2021 unless you had a company policy.
Yeah,
because
I'm just making it.
Okay.
I'm just picking a date, right? Randomly.
Right.
Say they started 5 years ago, really doesn't matter.
Oh, that's
so,
incredibly
but without a policy. Yeah. So, I mean, it makes it very difficult to track all of this. It'd be nice to just have mind you, it makes sense because after this year, your dates can be completely different as well.
Yeah, that's interesting. I mean, if you have a situation where that comes up and you need a bit of advice, I can have somebody look into it. Exactly. Sometimes the Ministry of Labor, their interpretations sometimes don't match with the law is the other thing. Now, it could be that that's the way they've interpreted it because it's the way the legislation is drafted. But it's funny that it comes into effect on Jan 1 of this year. There would be no retroactive effect, you would think, right? But okay, that's fascinating that they've interpreted it that way, because my clients haven't run into that issue yet, and a lot of them have A lot of these are very small companies who happen to have very transient workforces where they are the exact kind of people who will say, I want to take my 5 days leave, come back in 3 months and get another 5 days. So I will take a look at that and just check, because it hasn't come up yet. That's a very good question.
That'd be good. It's a very possible I phone and talk to a different person and get a completely different answer, but that's when I was just trying to be, you know, knowledgeable and accurate on the subject for my own employees.
Yeah,
that's what I learned.
Yeah, that's fascinating, because we contacted them about a different issue, and nothing like that ever came up, because it was really about, okay, Jan 1 everybody gets 5 days, not Jan 1 everybody gets 5 days, and then as soon as their anniversary comes up, they get another 5 days. Now, I do know that they're not stackable, so they would never get 10 days, but the point is they could use the 5 days and then reset to 0 and then get another 5 days partway through the year. That would be unfortunate on its own. And then same thing is if somebody, you know, if you have a seasonal workforce, somebody comes in, they're working, you know, you got a bunch of events going on in you know, around the start of the year, and then there's a gap, and then something in the summer, and they come back, and then they get another 5 days. That situation hasn't come up yet either, but that is another one where we might see the Ministry of Labor saying, no, it's new employment, so they get another 5 days. The whole thing is frustrating because, as I say, I've had some clients with some real abuse issues for those sick days, and they're livid about this. And again, you know, it's come out of the pandemic that people think that paid sick days are important, and I'm not saying they're not, but there hasn't been a lot of planning for these sort of technicalities. So.
Yeah.
Okay. I don't think I saw any other comments or questions. It's possible I missed some though. So if Anna, if there are any that you saw that I didn't see, please let me know. But I don't think there are any. I've looked at the chat here. Jeff, I assume you don't see any either.
There was one about the portal, the member portal. So I sent out it's the regular ARArental.org site. You just have to log in with your existing username and password and click on that resources for human resources, and that'll link you right over there. We will be sending out the slides. So again, that'll have those step-by-step instructions. And should you need to reset your password, please reach out. Shannon did put her information in the chat box as well. But when we send out the recap with the slides, we'll also include her information in there to help everybody out. The one news that I did want to share, and this just happened 2 days ago, we have the ARA job portal where we have it expanding to 15 different national job boards. As of 2 days ago, we actually contracted with Career Builders, Facebook Jobs, and Google Jobs, which, you know, I think will be advantageous for all of our members in Region 10 to take advantage of that. So everybody does get the 5 free postings on that. It may be another, I think they're just working through some of the back end procedures on that, but that will be alive for all of our members across all 10 regions. So excited to kind of get that ball rolling as well.
Okay, great. And yeah, so Anna, just let me know there's no other questions that we got. So again, if people have questions offline, you've now seen how to use that advice request form, and to reach out to me or somebody else in one of our offices.
Thank you, Michael. Appreciate your time. And again, if you guys need anything, you can reach out to myself or to Shannon. Thanks, everybody.
Bye, everybody.